lots of matters relating to interpreting modern awards, enterprise agreements, drafting of employment contracts, commission structures, subcontracts, independent contractor agreements, and so on, as well as issues such as how to manage performance, how to manage the potential claims of unfair dismissal, breach of general protections, etc. And so employment is an area that we deal with very, very frequently. And I would estimate probably around about a quarter to a third of inquiries relate to employment to some degree. And one of the biggest, most common questions are engaging people as employees or independent contractors. And so this webinar, we'll go through some differences between these different modes of engagement, some pitfalls you've got to look out for, and some considerations around which one you might want to choose. We'll move on to the next top issue, which is to discuss what is an employment agreement. Now, an employment agreement is a contract between you, the employer, and the employee. My apologies if any of you are in the position of employees, but this is also for you as well, so you know your rights. And the employment agreement sets out the terms and conditions of the employment relationship. As a corollary to that, if you're dealing with independent contractor agreements as well, the terms and independent contractor agreement also sets out the terms and conditions of the contractor relationship. And we'll discuss about the features of employment relationships and contractor relationships later on in this webinar, because the distinction is quite important. Now, what clauses should be included in employment agreements? Well, the slide has a smorgasbord of them here. Some of the common ones that I find missing from a lot of employment agreements are things like protection of confidential information, non-solicitation of the employer's customers and other employees of the employer, protection of intellectual property, and if the employee is being paid above award, then whether that above award portion can be set off against claims that might be made for entitlements under an award, such as overtime allowances and so on. So I would recommend that even if you are using one of our templates, that you get the document reviewed by a lawyer, because there might be some specific clauses that are appropriate and should be added for your particular type of business that you might not be aware of. So a lawyer can, one of us, we can review the document that you've drafted and advise you on anything that might not be relevant and other things that might be relevant, but that are not included as well. Okay, and on to the next slide. Okay, so choosing the right employment type. So there are, broadly speaking, two categories of employment. One is permanent employees, which are your full-time and part-time employees, and the other are casuals. And if you just switch into the next slide, Ryan. Sorry, I'll move on to this in a moment. But the main difference between permanent and casual is that with permanent employees, there's an expectation of ongoing employment, be it on a full-time or a part-time basis. Whereas with casuals, there is no expectation of ongoing employment or even regular employment. A bit of a pop quiz, pop with a question mark. See if you can guess or perhaps find the answers to these questions. Number one is you don't need to pay an independent contractor any superannuation. Do you or don't you? And number two, you can terminate a full-time employee with only 2 weeks notice, and we'll touch on these topics a little bit later on in the webinar. So a full-time employee. All right, so a full-time employee is a permanent employee with an expectation of ongoing regular employment who works on average around 38 hours each week. Now, at law, it is 38 hours that they have to work as a minimum. And those hours can be averaged over a roster cycle. So if you've got a roster cycle that goes on for 4 weeks, then an employee is a full-time employee if the average number of hours during that cycle is 38, or is at least 38. Now, in some situations, you don't have a roster cycle. So in that case, it'll just be 38 hours each week. Just be mindful that if your employees work hours that are in excess of 38 hours, they might be entitled to overtime, depending on whether an award or an enterprise agreement applies and what your employment contract says. With all permanent employees, whether they're full-time or part-time, terminating those employees requires a notice period, and the notice period depends on their length of service, and it also depends on their employment contract. So if you've been employed, if an employee has been working at your business for at least 1 year, we'll have a table later on talking about termination notice periods, but basically it ranges between 1 to 4 weeks notice, depending on how long they've been working in your business. If they are aged over 45 and have been serving in your business for at least 2 years, then there's an additional 1 week on top. If an award doesn't apply, then the minimum requirements of the Fair Work Act apply. And if you've got terms in your employment contract that are in excess of those minimum notice periods, then as an employer, you have to comply with those terms as well. And look to the next slide. So advantages of full-time employees. There's no need to pay any casual loading. So if you're employing a casual, there's a 25% leave loading that goes on, sorry, not leave loading, casual loading that needs to be paid on top of the base salary. You don't need to necessarily track work hours, but if an award applies and you do need to keep your eye on things like overtime, then you still do need to track the number of hours that are worked. If you're dealing with an award-free employee, so an employee for whom an award doesn't apply, then you might just set an annual salary and fixed set of hours, and they might be expected to work reasonable hours on top. Generally speaking, with full-time employees, you tend to get a bit more loyalty out of the employee because there's a security of tenure, security of work, also there's a bit more, especially with award-free employees, a bit more flexibility around the kind of work hours they could do and the duties that they do as well. There is a mention in this slide about employee share option plans. It's not limited to full-time employees. You can also have employee share option plans for part-time employees as well, and as well as casuals, and even in some cases contractors. You can offer them these option plans if you want to incentivize an employee to stay on for a long period of time and get equity in your business, in your company. Okay, next slide. Part-time employees. So part-time employees are permanent employees, again, with the expectation of continuing employment, but they are working less than 38 hours per week. You've got to remember that in some modern awards, there are minimum hours of engagement requirements. So, for example, under the Social, Community and Disability Support Award, the SHADS Award, if an employee is working on a part-time basis or a casual basis, then the minimum hours of engagement can range between 2 to 3 hours, depending on the type of occupation they are working in. These minimum hours requirement also applies to a lot of other awards as well. So check your award, make sure that you're not in breach of that. Like full-time employees, part-time employees are also entitled to written notice if they are being terminated, and they're also entitled to accrue leave, annual leave, personal carers leave, etc. Same as a full-time employee, except on the basis of the number of hours, it's prorated. So if you're talking about, let's say, so with a full-time employee, you get 4 weeks of annual leave per 12 months of service. With a part-time employee, you also get 4 weeks of leave per 12 months of service. But if you look at the number of hours that those 4 weeks of leave consist of, then for part-time employees, it's prorated according to the number of hours they work. In the next slide. So with part-time employees, the advantages are that you have potentially a greater pool of candidates that are available to you. Mums returning to the workforce and experienced workers who might be transitioning to retirement, for instance, as well as students who might be studying and looking to work part-time as well. All of these people, they have skills, they have knowledge, experience, and attributes that might be valuable to your business. And if you're limiting yourself to engaging only full-time employees, then you miss out on that talent pool. So allowing for part-time employees in your workplace can broaden the talent pool that's available for your consideration. It's also helpful if you've got a new role, if you're creating a new role, but the amount of work for that role doesn't justify a full-time position. So you can set up a part-time position, perhaps a part-time fixed-term position, and then just see how that role goes, whether you're going to continue needing that role or expand that role. So you can use part-time positions to sort of experiment with any new role that you might want to introduce. And of course, if a role, whether it's a new role or an existing role, doesn't require a full-time employee, then it will also save you cost, because you only need to pay the person, you only need to pay the employee on a part-time basis. Next slide. Now, casual employees. So contrary to permanent employees, casual employees don't have a right to expect ongoing, continuing regular employment. And casual employees receive a loading, 25% casual loading on top of their base rate. And under some awards, in fact, under most awards, there will be a prescribed minimum number of hours per shift, usually somewhere between 2 to 4 hours. So check your award. Casual employees also don't accrue any leave in the way that permanent employees do. So in lieu of getting, say, annual leave, they receive that 25% casual loading instead. And under the Fair Work Act, at least if you look at the minimum requirements, there is no requirement to give a notice of termination. I'm not sure whether there is any award that requires a minimum notice. Most of the awards refer back to the National Employment Standards under the Fair Work Act. But check your award anyway, just in case. I find that in most employment contracts, it does say that a casual employee will receive, let's say, 1 business day's notice prior to termination. It leaves a bit of a sour taste in the employee's mouth if they turn up to work and then just suddenly told that they don't have a job. So as a matter of courtesy, I find that most employer clients will allow for some notice when terminating a casual employee. And casual employees don't receive redundancy pay, unlike permanent employees who might be entitled to redundancy pay depending on their length of service. Okay, so advantages, biggest advantage is probably flexibility. So if you've got a role and where the amount of work is going to vary over time, then employing a casual will give you that flexibility to adjust the number of hours they work, and not just the number of hours, but also the hours, the start and finishing times of their job. Casual employees, so because they're casual and they don't have a legal right to expect ongoing continuing employment, there is arguably fewer chances of unfair dismissal claims, and that there's no leave entitlements for you to deal with. No redundancy pay. There's usually minimum notice of termination, depending on what you've got in your employment contract. And casual employees, you can use casual roles to assess the suitability of an individual for a role. So you find a lot of employers, you might engage somebody as a casual and then eventually convert them into part-time or full-time roles if that person proves themselves to be suitable for that role. Mention a risk in there. We'll move on to the next slide. Sorry, can we just go back to the previous slide there, Aaron? So the risk with casual employees is that if they've been with you for at least 12 months and they have worked regular systematic hours for at least the last 6 months of their employment, then they may be entitled to conversion to permanent full-time or part-time status. If you are an employer with 15 or more employees, then you're required to proactively offer conversion. Or if you're not going to offer conversion, then to proactively inform the employee that you won't be offering conversion because, for example, you cannot guarantee or expect or anticipate that their work will continue on a regular basis going forward into the future. If you're a small business with less than 15 employees, then the employee can ask, but you are not required to proactively offer conversion. So there's a bit of a difference there. Conversion, whether you decide to agree to convert the employee or offer conversion to the employee will depend on your anticipated future workload for that role, and if you think that that role, that the hours that they're working won't continue in the current pattern, then there is a reasonable basis for making that assumption, for determining that, then you would be entitled to not offer conversion or to refuse to convert if a conversion request is received. And the next slide. All right, contractors. So next slide, Ryan, sorry. So a contractor is not an employee. A contractor is a business operator in their own right, who you are engaging to do work for your business. And usually you would engage a contractor to perform a particular task or a project. Sometimes I find employer clients engage contractors to do ongoing work. There is a bit of a risk that if you do that, the relationship will be deemed to be an employment relationship rather than a contractor relationship. But you can engage contractors in that way. You just got to be very careful about how you go about doing that. So features of a contractor: there is no minimum pay rate because the employment laws do not apply. So you negotiate the rate of pay on a business-to-business basis. Because the contractors are not your employees, you have less control over how their work is done. So normally with a contractor, you tell the contractor the outcome that you want achieved, and the contractor will use their own knowledge and skill to achieve that outcome. Whereas with an employee, you might have specific set processes, procedures, performance standards that you set, which they must follow, etc. And so you can exercise a fairly close degree of supervision over employees. But with contractors, they generally given much more freedom to go about to decide how they go about doing their work, and the courts expect that contractors will be given that freedom. If not, if you end up micromanaging contractors, like as with an employee, then there is a risk that the relationship will be deemed to be an employment relationship, not a contractor relationship. Contractors can also accept and refuse jobs as they see fit. They don't receive any leave. Leave entitlements fall under the employment law, and unless if your contractor agreement says so, they're not promised continuing work. Now, some contractor agreements might have a requirement for contractors to provide notice of when they're taking time off. Again, that is a feature of employment contracts, and so if you have a requirement like that in your contractor agreement, then you increase the risk of that relationship being deemed to be an employment relationship rather than a contractor relationship. And very importantly, contractors will invoice your business for payment in accordance with the calculation of pay in their agreement. Next slide. So advantages: if you don't want to burden yourself with the compliance requirements for employees, then you might wish to engage somebody as a contractor. If you want to engage somebody who on a business-to-business basis with a lot of flexibility, then and sacrifice a degree of control, then engaging somebody as a contractor might be a good idea. And also, if you only need somebody for a particular project or a task, then your options are that you could engage somebody on a fixed term basis as an employee, or you engage a contractor for that project on a business-to-business basis. And generally speaking, the contractor will provide their own materials and equipment, so you don't have to fork out your own expense for that. Now, we'll move on to the next slide regarding the risk. So the biggest risk with contractors is misclassification. So if the terms of your relationship with a contractor resembles that of an employee and an employer, then the Fair Work Commission or the courts can order payment of compensation, as well as payment of penalties for sham contracting. So you've got to look at the terms of the engagement of the contractor and weigh up the various factors, so various features, whether those features reflect an employment relationship or a contractor relationship. And we'll discuss some of those features in a moment. There is safety risk. So with contractors, they would not, one would expect, not be as familiar with workplace health and safety protocols and processes in the same way as your employees. And contractors can do things in ways that are different from what your employees are used to. And so that might, depending on the industry, increase the occurrence of workplace injury and hazards. Contractors are business in their own right. And so they may have ways of doing things in terms of protecting confidential information and intellectual property that are different from yours. And so there is an increased risk of security breaches of confidential information, etc. Also, contractors are not bound by the common law duty of confidentiality and loyalty that employees are usually bound by. So contractors are not bound to be loyal to you or avoid conflicts of interest or keep your information confidential unless you specify those obligations in your contractor agreement. And as I mentioned before, there's a lesser degree of control over how your contractors perform their work. And so if you're concerned about quality control, you might not have that level of control that you want with contractors. And also with intellectual property, because they're business in their own right, they generally will have claim to intellectual property rights over the things they create, even if it's as part of performing work for your business. And so in your contractor agreement, you need to have a clause or a set of clauses protecting your intellectual property rights. So any intellectual property that the contractor creates using your material or as part of performing their services to you will be assigned to you, will be assigned to your business. And also obligations to protect your business's confidential info, your business clients' confidential information as well, et cetera, in order to mitigate against these legal risks. Next slide. I'll just flip back into the previous slide, sorry. So with misclassification, I mentioned about different factors that weigh in favor of a person being classed as an employee or as a contractor. Now, the law at the moment, it has changed in recent times. It used to be the case that the courts will look at the overall conduct of the parties when determining whether they are an employer or contractor, and the written the written agreement between the parties would be one of the things that the court will look at. The law has since changed, and now the starting point is the agreement, the terms of the agreement between the parties. And then what the court will do is look at the features of the agreement, the terms of the agreement, and decide whether those terms reflect an employment relationship or a contractor relationship. So having written agreements for your employees and contractors are very important if you want to avoid a dispute about whether a worker has been correctly classified as a contractor or an employee. Now, some of the features, some of the terms that might lead to a worker being classed as an employee rather than a contractor would be, for instance, if you provide them with equipment, if you require them to wear things like uniforms, wear your branded gear, drive a branded company car, if you require them to provide notice before taking time off, if you do not provide them with a choice of accepting or rejecting work, if you do not allow them to delegate their work to their own employees or subcontractors, all of those features are features that weigh in favor of that worker being an employee rather than a contractor. With a contractor, there's usually a freedom to contract, so freedom to accept or reject work, freedom to engage with other businesses, including businesses that might be in competition with yours. There is usually a right to delegation, so the contractor would have the right to delegate work they are doing for your business to their own employees or their own subcontractors within reason. I mean, you might want to verify whether an employer or subcontractor is appropriately qualified for the task. Contractors usually provide their own equipment and their own gear. They will usually have their own insurance, professional indemnity insurance, workers' compensation, public liability, etc. And so those are features that weigh in favor of a worker being classed as a contractor rather than an employee. So if you have any doubts about whether a contractor agreement you're planning to enter into puts that relationship at risk of being deemed to be an employment relationship instead, talk to a lawyer, get that contract reviewed and amended appropriately. Next couple of slides. All right, intellectual property. So for employees, there is a presumption in general law that any intellectual property that an employee creates as part of their employment, as part of their duties, would belong to their employer and not the employee. Now, that assumption holds true if the employee is engaged to, if the employee's core duties involve creating intellectual property. So if they're if their role is like a graphic designer, then it goes without saying that they're going to create art designs and so on, and those things would belong to the employer. On the other hand, if they're doing mainly, say, administrative work where they're not really doing anything creative, then there's a bit of a question mark over whether the intellectual property they create would belong to the employer or not. And so in any case, we strongly recommend that your employment agreement includes provisions for the employee to assign any intellectual property they create as part of their work to your business, and not just any intellectual property they create as part of doing their work, but also those that might be derived from your business's existing intellectual property or your resources. So if your employee uses your template documents, or they use your computer, etc., or software packages to create intellectual property, those should belong to your business and not the employee. You should also ensure that your business's confidential information is protected. So your employment agreement should have a confidentiality clause defining what that confidential information is, and prohibiting your employee from disclosing or using that confidential information without your permission. When you're terminating somebody's employment, or if an employee resigns, you would ordinarily confirm that termination or resignation in writing via a letter. And what we suggest you do is you include a little blurb in there about their confidentiality and intellectual property obligations, returning material that they possess, which contains confidential info, providing you with originals and copies of an intellectual property that they've created, etc. Now, if you find that your employee has misused or is leaking confidential information from your business, take action quickly. The usual thing to do would be to issue a cease and desist letter to the employee. If they do not comply, then your next option would be to seek an injunction, which is an order from the court that says that a person cannot do certain things. Injunctions, in order to maximize your chance of obtaining an injunction, it needs to be applied for quickly. If you delay, then you reduce your chance of getting an injunction, because injunctions are usually, they're urgent applications. They're orders that you would argue that the court needs to make quickly in order to avoid harm to your business, and so delay can reduce your chances of being able to successfully obtain an injunction. It is a fairly expensive process and quite a complicated process as well. So always get specialist legal advice before you take that step. But you really shouldn't ignore confidential information being leaked or being misused by your employee for their or a third party's benefit. So yeah, just keep your eye out for those issues. Next slide. All right, this issue of managing annual leave and holiday shutdowns, it's coming up more and more frequently now as we are approaching the holiday season. So we're on the next slide. So the question goes something like this. My business is shutting down for 2 weeks over Christmas, New Year's. Can I force all my employees to take annual leave for that time? And the answer to that depends, and it depends on whether a modern award applies and what the provisions of the award say about requiring employees to take annual leave. If a modern award doesn't apply, then it depends on the provisions of the Fair Work Act and your employment agreement. So if a modern award applies, most awards have provisions saying something like, an employer may require employees to take paid annual leave during a closure period, for example, Christmas and New Year public holidays. Now, normally that provision comes with a requirement to provide advance notice. The period of that advance notice depends on the award, but it can range between 4 weeks to about 3 months, depending on the award. So I think for the clerk's private sector award, it's about 4 weeks. I think for like fire sprinklers award, etc., it's like 2 months or 3 months. So check the award and check what the notice requirements are. Notice usually have to be put in writing as well. If the employee doesn't have sufficient leave accrued to cover that whole closure period, then the situation becomes a bit tricky. Now, in some awards, it allows for the employee to continue to take leave on a paid basis. But obviously, if they do that, their accrued annual leave will become a negative figure, right? And if the employee leaves their employment, if the employment is terminated or if the employee resigns before the accrued annual leave becomes zero or a positive figure, then the employer may recover the equivalent amount of pay from the termination entitlements of the employee. Now, some awards have this provision, some awards don't. So check your award. Some awards allow for the employee to be unpaid if they don't have sufficient leave accrued, but this is fairly rare. And if the award is silent about what to do if there is insufficient leave accruals, then you have to pay the employee regardless. Okay, so check the award. And then on to the next slide. Now, if the modern award doesn't apply, then under the Fair Work Act, an employer may require an employee to take paid annual leave if you're shut for a particular period. If the accrued annual leave is insufficient for that employee, then you can agree with the employee that they can take paid annual leave. And then if they do that, the accrued annual leave figure will become negative. And if the employment is terminated before it becomes zero or a positive figure, then the employer can recover from the termination entitlements of that employee the equivalent amount of pay. If the employee unfortunately doesn't agree with that, then you have to pay the employee regardless. So in your employment contracts, you should have a clause addressing this issue, so that if you're a type of business that closes during the Christmas New Year period or any other public holiday period, then it should have a clause to the effect that the employee may be required to take annual leave, and if they have insufficient leave, then whether they're then to allow them to be paid for that period when they don't have sufficient annual leave accrued, but allow the employer to recover the equivalent amount of pay for that period. Okay. If you've got any questions about this is a fairly tricky sort of topic, feel free to contact us and ask, and we can advise you on your particular circumstances. And then I'll pass you back on to Ryan.
Perfect. Thank you so much, Sam, for the very informative presentation on that. Now, I just wanted to cover how Lawpath can help. So we did a recent survey and we found that around 80% of individuals and 87% of SMBs can find it difficult to access the legal services that they need. There's a general perception that they find that it takes a long time, it's expensive and it's complicated. Even what Sam was sharing just then, it can be incredibly complex to even kind of identify the award that your employees are under, and then keeping track of all the entitlements to ensure that you stay compliant. So how Lawpath can help. So we have a contract management system, which has around 372 documents right now, and it includes over 100 different HR and employment documentation, everything from a employment agreement to your employee handbook, conversion letters if you're transferring from a casual or a part-time into a full-time employment. We have all of those documents there, and our contract management system does walk you through each of the steps to ensure that you do fill it out and that it's compliant. We do have a range of personalized workflows, particularly around hiring an employee and also a contractor, to ensure that you're doing the necessary steps and staying compliant. And the workflows do direct you to the specific documents that you do need, but they do provide a lot of value outside of the actual documents themselves. So we have free templates you can use and ebooks to help you along the way as well. And lastly, booking and legal consultations. So if you'd like to review some documents you've made using our documents library and get them reviewed by Sam or Damon or one of our lawyers on the plan, then you can always do that and get on-demand legal advice for your specific situation and business. So we do have a range of plans here, which you may be familiar with. We have our Essentials plan on the left-hand side, which includes the 372 documents. It's continually growing each week, and that one includes e-signature as well. You can also add in 3 team members. If you have a team of people you want to delegate the work to, potentially as well, you want to download these documents into a PDF or Word document format, which is totally fine. Then we have our legal advice plan. So that includes the templates and e-sign, but it also includes the on-demand legal advice. So you might want to have on-demand legal advice with our lawyers to discuss your circumstances or to get up to 4 pages of contracts reviewed. So this is a fantastic plan to get compliance and to ensure that you're on the right track, which we have an accelerator program for on 6 different topics as well. So it would cover everything from reviewing your employment agreements to intellectual property provisions and all the way through to capital raising and even ESOP. If you want to issue shares out, that can be done through the accelerator program, which is currently offered complimentary on the plan. And lastly, our legal and accounting advice includes the legal advice and the documents, but it includes unlimited 30-minute calls from our chartered accountants. So if you require high-level advice on, say, group structuring, asset protection, paying yourself as a director through the business, then this can be a phenomenal plan to get that high-level advice, as well as we offer ASIC and ATO agent service. So if you need to make company changes throughout the year, then our company's team can make that on your behalf. Again, this has its own dedicated accelerator program on topics around asset protection, group structuring, budgeting and forecasting liabilities as they fall due and the like on that plan. So for today's webinar offer, if you've enjoyed what Sam has shared about and you'd love to jump on our legal advice plan and get some tailored advice for your business or some documents reviewed, we're offering 20% off. So it's $100 a month, monthly billing with an annual commitment. Or perhaps we have a 3-month trial that you'd like to get started on without a long-term commitment. and you just want to see if it's a good fit for your business, access the templates and potentially try out the accounting plan as well. So if you do like either of these offers or you are interested in them, then please comment yes in the chat below, and one of our team will be in touch after the webinar for some information on how to redeem these offers. So I'm going to pass it back to Sam. I believe we have some questions and answers. If you do have any further questions or answers off the back of the presentation, now is the time to pop them in the Q&A box or the chat window, and Sam will answer all your questions right now. Thanks, Sam.
Thanks, Ryan. So we've got a few questions here. Audrey, you asked, do you need to offer a casual permanent work after 1 year? It depends. So if the casual worker has been working with you for at least 1 year, and during the last 6 months of their work, they have been working regular systematic hours, then they are entitled to either ask for conversion to permanent employment, or you as the employer may be required to offer them conversion to permanent employment. So it depends on whether whether they have worked with you for at least a year, and whether during the last 6 months they've been working regular hours. Now, you are not required to convert them to permanent employee if you cannot reasonably provide the continuing regular hours of work thereafter. So, obviously, if your business is not in a position to, so let's say that you had an employee who's been working with you for at least a year, and during the last 6 months, they've been working on, Tuesdays, Thursdays, and Saturdays from 9 a.m. to 3 p.m., right? If your business is no longer going to do that because of some operational reason, then that would be a reason why you wouldn't convert that person to a permanent. Okay, but you've got to have a reasonable basis for that. You can't just, out of spite, change their work hours in order to avoid your conversion obligations. So you've got to be reasonable about it. But yeah, if you've got a genuine business operational need or a business change, and you can't continue their regular pattern of hours after conversion, then you are not required to convert them. So it depends on your situation. But the threshold requirement is that they've got to have been working with you for at least a year, and during the last 6 months, they need to have worked regular systematic hours. Harry, you asked, would a contractor invoice payment attract payroll tax in case of IT consulting? This is a bit of a thorny issue. So payroll tax can apply to remuneration paid to contractors. Now, I'm not, this is more of a tax question, but my understanding is that if you engage that person on a personal basis, and so not through a company, and they're providing services based on their personal skill or labor, and you're paying them on that basis, then payroll tax would apply. But I would recommend that you speak to your tax accountant about that, and get detailed advice about your particular circumstances, and whether the terms of the consulting agreement that you have would result in you being liable for payroll tax for that person. Payroll tax rules also differ between different states and territories as well. So I don't know where you are based at, but have a chat with your tax accountant about it. Audrey, you asked again, is a contractor the same as a VA, a virtual assistant? I find that most virtual assistants, in fact, every one of them, would be engaged as a contractor. So yeah, the pattern seems to be that VAs are normally working as contractors, and they are operating business their own right, usually serving multiple businesses as VAs. And so yeah, it'll be a contractor arrangement. Whether a court or the Fair Work Commission would assess it as such would depend on the exact terms of the contractor arrangement. So if you've got any doubts, get that contractor agreement reviewed. Nicola, if a contractor has an ABN but is a sole trader, can they operate as a contractor? Well, yes, they can. So contractor relationship is a business-to-business relationship. So if your contractor has an ABN and operates a business as a sole trader, then yes, they can be engaged by other businesses to work as a contractor. Yeah, so that's the basic answer. The more nuanced answer is you'll need to consider carefully what provisions will be in the contractor agreement, because then that would impact on whether government authorities or the courts will regard that contractor as a contractor or as an employee. I should just mention as well, because there was a question in one of the slides about this, and I forgot to address it during the presentation. But contractors, you may be required to pay superannuation for contractors. So that requirement arises if you engage a contractor in their own personal capacity, so not through, say, a company that they formed. So if you engage a contractor personally, that contractor provides personal services and are paid for their labor, for example, on an hourly rate or a day rate, as opposed to, say, a fixed fee for a quoted project. And they cannot subcontract or delegate their work to others, then you have to pay superannuation. So have a chat with your accountant if you've got any doubts about that. I would also recommend that in your contractor agreements, you include a provision around delegation of work, so that they can, I mean, if their services are suitable for delegation, that they are able to delegate their work to their own employees or subcontractors. You might want to include a provision that you need to approve that delegation as well. But yeah, have a look at your contract agreement and draft, and then get a lawyer to draft some appropriate wording around that issue. Nicola, you also made an observation. It says, so ATO says ability to subcontract delegate. I'm not sure sort of where you're going with that one. So the ATO for superannuation purposes will have their own definition of what an employee or an employer or a contractor is. It's broader than the common law definition, so the definition of the general law. Yeah, I've just mentioned, I've gone over it very briefly just a few moments ago. But yeah, have a chat to your accountant if you've got any doubts about whether you need to pay superannuation for your contractor. An anonymous attendee has asked, the ATO employee versus contractor definition makes it almost impossible to engage a sole trader contractor without it being a sham contract. What are the options to engage? Well, okay, so a sham contract, it's not. So yes, the ATO has a broader definition of employee than under general law, as I just mentioned. And so even if somebody is a contractor under general law, you may still be required to pay superannuation to that contractor. Now, it's not necessarily a sham contract. A sham contract is when you have an employment relationship, which you then disguise as a contractor relationship. So that might happen if you tell an employee that they need an ABN and they need to issue your business with an invoice for you to be able to pay them. So if you falsely tell an employee that sort of nonsense, and the employee buys into that and registers an ABN and enters into a contractor agreement with you, then that would be a sham contract. On the other hand, if your worker and you, if a contractor and you have had a genuine discussion about engaging them as a contractor, and they're aware of the issues, and you know you've negotiated a contractor agreement and into it, and the terms of the contractor agreement reflect a contractor relationship rather than an employment relationship, then that's not a sham contract. You might be, depending on the terms, it might be debatable whether that person is a contractor or an employee in substance, but a sham contract requires some degree of deceit. Most of the time, lawsuits around sham contracts, that they involve a fairly high degree of proof. If you genuinely made a mistake about classifying a person correct, subcontractor, as a contractor or an employee. It's usually not a sham contracting issue, but the risk is still there. Now, if you're engaging a sole trading contractor as a sole trader, again, you need to look at the factors that that influence whether a person is a contractor or an employee. Things like delegation of work, quality control over work, how they're remunerated, leave notices, etc., provision of equipment, and so on. And yeah, just make sure that that the balance weighs in favor of them being a contractor or an employee. And I think I've also answered the one last question. So I'll flick it back to you, Ryan.
Perfect. Thank you so much, Sam, for the Q&A. I hope a lot of people got value from that, and to everyone who attended the webinar today. So just closing off again, just to reiterate the offer that we have going on, we've got 20% off the legal advice plan and our 3-month trial. If you are keen, type yes in the box below and we'll be in touch. Otherwise, thank you to everyone who attended today's webinar. I'm going to pop up a feedback poll now, so feel free to fill that in. Let us know how we can improve so we can launch more webinars that are niche for your business and relevant. But again, thank you so much to everyone who attended. And just lastly, we will have the recording on YouTube as well within the coming 1 to 2 days, so you can watch it back. Thanks everyone for your time.